Hi everyone, it's Rob Ryder. Today is Wednesday, April 25th, 2018. And the name game in the UCC is the true full name, debtor, of the full legal name. And or is the grantee, borrower, lender, trustee, debtors of the full legal name. So this has to do with UCC-1 financial statements. Who's the debtor? Who's the secured party, creditor? Well, how about if we make the true full name the debtor and the full legal name the creditor overall? But more specifically then, if you have real estate, how about we make the grantee borrower, which is supposed to be you, but it isn't, it's a legal fiction, the lender, and the trustee, if you have a deed of trust, but if you have a mortgage, you won't have a trustee, debtors of you and your full legal name as the creditor. Because none of these documents do they ever use your full legal name. And when we see what the definitions are, you'd say, well, yeah, these people could be the debtor just as easy as anybody else can be. So make them the debtor and make the collateral be the deed of trust and all the personal and real property incorporated by reference. Fill out a UCC, and then you'll have secured your security interest in the property. We'll have to see exactly what it says you can do. But that's the idea, right? So this can be about looking at a UCC form and looking at deed of trust, warranty deed, things to do with real estate, and say, what will we pull off of here to put on this form to send in to say, hey, I have an interest in that property, because right now you don't have one. And this is one more step after claiming your name, which is to do a DBA on the name that's on the as the borrower / grantee, because it appears they're using the same name. And if not, well, then you have to do two different names. But those are names that you want to claim because they're supposed to have been you. And so your property is involved in these things where they're using a name that's supposed to have been you, but you're not involved. And the only way to get involved to secure your interest is to file, a DBA to say, hey, I was doing business in an assumed name. I do have interest in that. And then to secure your security interest by filing a UCC filing. So let's see where this leads. Rob Ryder, that's my avatar. My email address is courtofrecord@aol.com. Phone number 616-712-6179, although I don't really have any answers. Please donate. It's how I eat, especially if you're going to call me. I mean, you don't need to donate because you call, but, hey, if you're calling me, man, right? You guys need to think about donating, because that is how I eat. My PayPal account is robryder@aol.com, or you can send it by mail to Robert Allen Retluski, 10955 14 Mile Road, Northeast, Rockford, Michigan, 49341, or Western Union, MoneyGram, Walmart, creative. There's ways to do it. Because this is for the common good. Right? I'm doing a lot of this. I don't have any property, so I'm not going to get any gain out of claiming the name on any real estate. But hopefully you can, if you haven't. So there's a difference in names. Let's just start with a couple things that are true, right? Here's the evidence. A California driver's license is a card that grants permission to an individual to operate a motor vehicle. A DL includes your true full name. So you look at what a true full name would be, because it's on the California driver's license. Well, it's your last name, first name. Doe Judy Jane. Retluski, Robert Allen. Or without a comma. Why would you have a comma in your name? Right? It really isn't a name if it has a comma in it, is it? I don't know. But they use it in California. And they also use it for people that had gone to Minnesota to do a DBA, if you read what it says to use it for, use this form to file an assumed name. Assumed name filing should be used when a person conducting business under a name which does not contain their true full name. So it doesn't contain Rutluski, Robert Allen, surname, comma, given name. Right? In Oregon, they defined real and true name. Right? So it's got the same words. The surname of an individual coupled with the combination of the individual's given names and initials. Well, there's those initials, and we really want to stay away from initials. But if you said the combination of the individual's surname coupled with their given name, well, the coupler would be a comma. Or we just put them together. What is it they're actually saying? But whatever they're saying, the surname came first. It didn't start with what you would say is your first name. They're starting with your surname. And so those are different styles of names. Right? Because a legal name is the name that identifies a person for legal, administrative, and other official purposes. Usually the name found on your birth documents. And unless you've had a legal name change, then it still is the name that's on your birth documents. Even if you're a married woman, if you don't have a gold seal from somebody saying that you changed your name from, your name that was on your birth record to your husband's name as your last name, well, your legal name is still the same. You can use the other name, that's fine, but your full legal name is actually your maiden name. And a full legal name is an individual's first name, middle name, last name, or surname without use of initials or nicknames. So if you start looking at paper and seeing attorneys using names with initials, understand they're not using their full legal name. And so whatever they're engaged in is not legal. If they're not using your full legal name, first name, middle name, last name, it's illegal. And even if they do, if they add to it by putting a comma and adding to it to create a grantee, well, then it's no longer your full legal name. No, it's a legal fiction that uses part of your legal name. But it would be doing business in a name other than your full legal name, because it's your full legal name, comma, husband and wife or something like that. And we'll see how that all fits together. But those are, they play with the names. There's just no way around it, right? And when you look, they play with the names of many things. Kent County, County of Kent, lowercase state of Michigan, proper case state of Michigan. Right, the proper name of a court compared to what it's really called, because everything really has one legal name, and anything else it has is a nickname. And we may know the nickname's better, but it doesn't mean it doesn't have a legal name. And so we're going to see about making these true full names, which is Rutluski Robert Allen, the debtor, on a UCC-1, which is what I did. But another thing to do would be to take the grantee borrower, which is supposed to be you, and make that a debtor, make the lender a debtor, and make the trustee a debtor on a deed of trust or mortgage to you and your full legal name, because they're out there, they all claim to have an interest in property that you have an interest in, and you've never secured your interest in the property that they claim to have an interest in, but they've never recorded their interest either. I just don't believe we're going to find that these people have ever recorded anything. That's what they do. They don't record stuff. They pretend to record. So let's see where we go next. So give me just a second to get a few sheets up. Okay, so because I have this document, certified copy of record of birth, that I've had since I was a young child, that shows that record of birth of Robert Allen Rutluski, now remaining in my office in the whole thereof. Right? So Why is my birth record remaining in the office of the clerk of the county of Bay and the circuit court thereof? What's the county of Bay? I thought it was Bay County. Right? These are questions you ask when you look at things. Circuit Court of Bay County, Michigan. Well, then why is it in the county of Bay? Why isn't it with the state of Michigan? It's my record of birth. If it's still in the clerk's office, nobody knows I was ever born. Right? So there's always that to consider. But then they also put this other thing, Rutluski, Robert Allen. Now, here's my name forward with the same words. There's no comma in it. But in this one, there's a comma. So it's like, okay, well, that really isn't a name then. That's a thing. That's more like an organization where it could be a new number of people that are operating this organization. Right? It could be like a trust. Or it could be the trustee of a trust. And the trustee, because it's an organization, has more than one person that can pull the levers. I being one of them and not knowing it, and somebody else who does know it, controlling my property. So I'm going to claim it as my debtor and say that it's holding property in trust. That was the idea, right? So I was going to base it on the information off of this form and fill out a UCC-1 form that you can do online now in Michigan, and so I did it that way instead. And it kind of went like this, right? That you go online on the Secretary of State's website, you say you want to do a UCC-1 filing, and you've already registered. So before I go any further, if you're going to do it online, or if you're ever going to do it, whenever you're talking about you and what's your name, you don't have a middle name. If you got more than one name, you have a given name. Make it your first name, right? So instead of Robert and Allen being first and middle, it's just Robert Allen, first name. That's my given name. Okay, so I had already registered for the system, and so it has my address and everything already set up. And now I'm going to go do my first UCC filing. And one of the things is you can send a copy to another email address, that you've done this. I don't know why you'd want to do that, but, you can. If you had the address of an attorney firm, you might want to send them a copy. I'm the owner. But what I did is I said that this is an organization, and I didn't say it was a transmitted utility, right? Transmitted utilities cannot be submitted online. Well, I don't want to be one. But I do want Rutluski Robert Allen to be an organization, not an individual. Because if it was an individual, it'd mean it was a living person, a natural person. And it's not. Natural person doesn't have a comma in their name. It's a thing. So it's an organization. So that's why I wanted to claim it as a debtor. Giving it my address that I have now, right? So that's what I did. That's the debtor. And it accepted it because I saved it. And there it is. There's the debtor as an organization. Then I went to the secured party and I made it an organization. My all caps name. I wanted to look. How did I do this here today? Okay. I didn't put it in all caps. So it isn't all caps here. I could have put it in all caps. It didn't stop me from doing it. I just wasn't thinking at the time, right? But if I do it again as an organization, just so that everybody would understand, I would probably have done it in all caps. Because I did everything else in all caps. Because I did, the secured party, which is me, as with an EIN instead of, with a social security number. And if you haven't watched my other videos, I did one some months ago about the EIN and SSN. It's about 4 months now, if you want to go back and watch it. Just please note, if you're going to get an EIN number, which I advocate everybody does as a sole proprietor in your own full legal name, mine's Robert Allen Rutluski, with the intention of getting a EIN number as a sole proprietor, don't use the form I'm showing online. Just go to the IRS website and do it online. Right? I didn't realize that was a pay site that I was using as an example. But you don't have to pay to do it. So, and get an EIN in your own name, and just real quick. Well, nothing's really quick when you're trying to do a video. It takes forever. Where did I put that? IRS. Right? You can do it online and they'll spit out online, send you by email, a copy of your SS4 form completed, showing that, this now is a business. It isn't you. It's you it's a business, sole proprietorship, that has its own number. It's no longer just your social security number. Now you have an EIN, an FEIN number, not just an EIN, a federal employer identification number. You're the employer of the federal. They have a duty to you. We just need to be properly registered. I'm thinking it's part of the problem. What was the other one here? And eventually you can, because I had to call them because I had a question. Why didn't I have a +4 for a address on here? Because when they talk about it, they call this your physical address, right? This is your physical address. This is my address within a federal district called the Postal Zone, 49341, right? I'm a resident of the Postal Zone. Because the state really isn't operating. We're under some kind of martial law, military rule, have been since the Civil War. That's why gold fringe flags are all over the place. And I complain about the things I complain about in my other videos. This isn't directly about that, but this is just to show that, hey, when you get your 147 form, which is the thing you're supposed to give to anybody who wants to know if you are, if you have an EIN to prove that you do, it comes with your +4 on it. So, I don't know how important that stuff is when you're filling forms out, but I guess it'd probably be good to try to stay consistent, if nothing else. All that to say, hey, that was me right there. All right, as if I had a place to put an EIN number, I'd have been putting it down. I wouldn't have been using my Social Security number. Didn't give me that opportunity. But as you can see, it let me save it. And why this is important is when I was trying this using my name as individual and using it as organization one and an individual in another, the system would not let me do it for the different variations I was trying. To say you can't have the same name of a debtor as you can as you do as the secured party. So it wouldn't let me do an organization, Robert Allen Rytlewski, and then an individual, Robert Allen Rytlewski, even though Robert Allen and Rytlewski were going in separate boxes. It said, no, same name. All these different combinations I tried, it wouldn't let me do it. But it would let me do it. It would let me do it when they were both organizations, and the debtor was Rytlewski, Robert Allen, and the secured party was Robert Allen Rytlewski. And so they're both organizations, and one is the debtor of the other, which technically is how it should be because they're the same species, right? They're both artificial persons. They're avatars. So I really, as a living man, can't go after a thing, Rytlewski, Robert Allen, but I can send my thing after it. Maybe that's why I took it. Because I know in the past, people have tried to do things like this when you fill the forms out, and they were able to record them in the county, but, that was the Tim Turner stuff that people may have got in trouble with. And I don't think they were doing it right. And I'm not trying to do it for the things they're trying to do it with. That wasn't the same as whatever the reason they were doing it then. Other than for me to say, well, that's my property. That's why I'm doing it. It's my debtor. Robert Allen Rytlewski isn't my debtor. It's my property. Right? Rytlewski, Robert Allen, it's my debtor. And then, so check the box, move on. Hey, fill out this. What's it for? This is the collateral. So I said it was the record. And then I said, and all hereditaments, which incorporated by reference, which means, any property. Any intangible rights, anything to do with anything that's in that record. record number 2137, lever F, page 2137. It's mine. Held in trust. It's the only one I did. I said, okay, I'm done, right? And so it's going to send a copy to the court of record. It says the debtors are Ucc Robert Allen in lowercase because that's the way I typed it, and then put secured party Robert Allen Ucc in uppercase because that's the way I typed it. Both of them are organizations. I wish I would have gone back and put leasee, leaseor instead of whatever we're at now, but to me they're all the same, I guess. And that was the collateral. Record of birth, which is the thing you saw with all that information on there, and all hereditaments incorporated by reference, because somehow that's my master file that leads to everything else in my way of thinking. Yep. And then filer name, that was me. Filer ID, paid my $15. Yep, do it online. Check. Pay some dollars. Here we go. And it was done. And then I did a UCC-1 search later because I had these things in my box now. And so, how do you do this? Why did I? Okay, because you go to here to search. You can do a UCC-1 search, which is for debtors. Put debtor information in. Yeah, that's what I plan on doing. What's the information? Search by debtor. It's an organization. Put my name in backwards. Search for the certificate and copies. Yada boom, bada boom. Paid the $10, and it showed that there were copies of things out there, which was really just my forms. Okay, so it just to show that it did find something, right? So it did find me as a debtor. Okay, hang on a second. Okay, and if I had been doing it on a form, apparently it would have looked like this, because this is how it printed out, right? That's the name of the contact, the email address, send acknowledgement to. If you see how I have Robert Allen Ucc in here, that's because that's like the care of line. And this all came off of some earlier videos I did, starting with SSNs and EINs, and then built on it from there with other things that go on with the post office and so forth, and what they consider these different address lines. And I'm just trying to do it the way that I read it to be. And well, they agree with me. Hell, they're going to send it, and I'll get something in the mail. If they sent it by mail, it would get to me, because that's just the care of line, right? Robert Allen Ucc, 10955, 14 Mile Road Northeast. That's the same address. That is the same address as the EIN number, right? Me as a business, 10955 14 Mile Road. So I'm sending it to me, the owner, care of my business. Yep. Except when I do that, I forget what one I was on. Hang on a second. Okay, so here it is. Organization. So if you were going to fill it out yourself, if you can't do it online and you were going to do this, it would look something like this. I'm just going to say it's held in trust and give it some kind of collateral. And so you might have a birth certificate instead, right? But I tell you, they use Ucc Robert Allen on stuff because that's how a court case will show up, right? That will be the name of the defendant on the docket. Forget what's on the paper they're using in the court. In the docket, they'll be putting a lien or something on Ucc Robert Allen or against his property that he's the trustee for. Well, now I have an interest in his property. Okay. One more second. Okay. So, you're asking yourself, well, why would you ever want to do something like this? This is my answer. Or I think that this is the organization, that this is the trustee for Ucc, Robert Allen, the trustee of the trust that has the corpus of my property in it. But it isn't a person, it's an organization. So there's more than one person that can throw the switches, right? And so this now would allow me to throw the switches if I say, well, it's my debtor. It also, by doing this, I got the state to agree, right, that Robert Allen Ritlewski, 10955 14 Mile Road Northeast, Rockford, Michigan, 49341 8664, exist and is doing business at this address as an organization. Not as me as a person, but as a business, because it's got a place to put organization or compared to individual, right? So, excuse me, it's like I'm differentiating my business personality from myself. So if they agree, this is this really any different than registering your fictitious name in the state of Minnesota, right? To get the state to have recognized that you've done that. And again, these are things I talked about in videos before. If you don't know what I'm talking about, never heard it before, but people have done that, and it's changed their sale dates and so forth, or got court cases dismissed for foreclosures and so forth. But I only heard the story once, and I never got any much feedback from very many other people if they've done it. But if they have, well, excellent. If not, well, I'm saying, well, this would be the same thing for me. Now, I've got the state to recognize that my business exists here in Michigan. And I don't believe that it did before. So, what else could you use it for? Well, the main thing then is, if other than to do it for yourself, and we'll just have to see how that works, because I've done it. I'll see if I get something in the mail that shows it made any difference. Will I start getting the mail for Ritlewski Robert Allen because I gave it the same address as I had? They didn't have an address for it before. I don't know, but I know that Ritlewski Robert Allen has shown up on papers before, like from the court. So somebody's using it. And, that's what the form looks like if you've not seen it before. But I'm thinking of trying to use it for something like a deed of trust or a mortgage. And let's just look at a few things in the law about it first before we go look at a deed. Well, let's look at the deed of trust and see what we're talking about here. Fictitious name. So here's the atypical deed of trust, right? And it's got 3 people on it, 3 offices. It's got the borrower, which, you are led to believe is you, but if you look at it, it's really a legal fiction. Guadalupe Moya 4 and Ladonna Carol Moya, comma, husband and wife. Well, had they not put comma, husband and wife, you could say, well, that's them and their full legal name, but they did put husband and wife, so no, it's a legal fiction. So it isn't you, but it's supposed to be you, so it owes you a debt. It's working for you, right? But because you did business in a name other than your full legal name, then technically you're supposed to file a assumed name certificate in the county. And if you don't, well, you can't maintain any action in a court, right? Because you're using an unregistered legal fiction to do business in. If you're not doing business in your full legal name, you need to register an assumed name certificate. Right? So any name other than Robert Allen Ritlewski, even if it's uppercase, that isn't the problem. Anything other than that, I would have to register as a DBA. Assumed name, fictitious name, whatever they call it. But I believe you need to do it at the county, even if they make it sound like it isn't that big a deal, because somewhere in the law, it will say that you need to have done this to maintain an action in court. Like on my form, it says technically, if you haven't done this and you're using a fictitious name to do business, like on a deed of trust, you're committing a misdemeanor every day. So apparently, we want to get it right. Okay, so that's one. Well, another one is the lender. Lender, Town Square Mortgage and Investment Incorporated, DBA, Town Square Financial. You'd be led to think that's a bank, but it isn't. There is no bank with that name. It's a legal fiction, right? So it's another entity that has a debt to you. It's acting in the place of somebody who says that they're a lender, right? Lender is a Georgia corporation, organized and existing under the laws of Texas. How can you be a Georgia corporation, organized and existing under the laws of Texas? You could exist under the laws of Texas, but I don't think you could be organized. I mean, to be organized means to be created. So there is no lender anywhere in, this is in Texas, that has a right to do mortgages in the name Town Square Mortgage and Investment Incorporated, DBA, Town Square Financial. But it is a legal fiction. Make it your debtor. And so is the trustee, Troy D. Phillips, PC, right? That is nobody's full legal name. It's a legal fiction made up using somebody's name, putting a middle initial in it instead, comma, PC. They create legal fictions. Again, it isn't anybody as an individual. It's an organization that owes you a debt. So all three of these would be organization debtors that you would put as the debtors on a UCC-1. Now, there's only room for 2 debtors on a UCC-1, so if you have a trustee, which you have on deeds of trust, you'd have to use the addendum that goes with it, right? Another one. And if there's, a husband and a wife, so there's more than one secured party, well, then you're going to have to use this also because there's only room for one secured party. But big deal, whatever it takes. So for a typical, transaction for real estate, you can get all the players on the, one form that you need to do under a UCC-1 and have it filed in the proper records to show your interest in the property that these legal fictions have somehow claiming to have some kind of authority over. How did things get your property? Let me just, I'm not going to read the whole thing, but UCC-1. See what Wikipedia has to say. All right, it's a financial statement, legal form that's filed by the creditors, that it has or may have an interest in the personal property of a debtor, right? Has or may have. You don't have to have, right? So you can't do it wrong. So there's no reason not to do it. If they'll let you do it, do it. Of a person who owes a debt to the creditor, right? So all these people on the deed of trust or all these entities owe you a debt because they're not using their full legal name, so they're hiding they're hiding the true names of the owners. Then, they must be your debtors. I'm going to make them my debtors. Pursuant to standards set forth in UCC-9, 503 and 504, the financial statement need only contain 3 pieces of information: debtor's name and address, creditor's name and address, and an indication of the collateral, whether or not it's specific, if it reasonably identifies what is described. That'd be in 9-108. Generally filed with the Secretary of State. However, an exception exists if the collateral is something that is tied to a particular piece of real property. Hey, real property, hey, what are we talking about now? Such as timbers, mineral rights, and fixtures. Do you know that your house is a fixture on the land or on the real property? It's just a fixture. You can do a fixture filing. In that case, the fixture must be made, the filing must be made in the county where the property is located, usually in the recording office or county court, because that is where third parties are most likely to search for such a record. So if you want to show your interest in the property that's on a deed of trust in your full legal name, you need to put all these debtors on a UCC-1 and say that, the property on the deed of trust is your property. Or at least you have an interest in it. Because, the reality is that nobody lent you any money. Nobody signed the deed of trust except for you. Or the mortgage, right? The bank didn't sign it. They didn't make you a loan. So they don't have any interest. Right? And the trustee doesn't have any interest because nobody signed the paperwork. They're just holding your property that has been put in, an escrow basically that you're giving to them, because if you ever you make payments, they go to escrow payments. Seems to me that's how they do it. Where does escrow fit in during the lifetime of a loan? I think it continues on. Anyways, that's why we're going to do it. In the case of a loan secured by personal property collateral, the filing of a financial statement gives notice of a lien against the property so that the other lenders or buyers of the personal property will know of the security interest. The personal property collateral. And so, how do they take it from being real property and so forth, and what's a fixture and all these, that's where the devil is in the details. Fixtures. Personal chattels annexed to land, right? Personal property annexed to land. Questions frequently arise as to whether fixtures are to be considered real estate or part of the freehold, or whether they are to be treated as personal property, right? So it looks like there's three different positions. As part of the real estate, as part of the freehold, or as part of personal property. To decide these, it's proper to consider the mode of annexation. What does that mean? By actual connexation or annexation is understood in every mode by which a chattel can be joined or united to a freehold. The article must not, however, be laid upon the ground. It must be fastened, fixed, or set into the land, or into some such erection as is unquestionably part of the reality. Okay, so your house is set into the land, but because of what it is, it's a fixture. It's not the land, right? It isn't necessarily the real estate, and it isn't necessarily part of the freehold. It could just be your personal property. You can take your personal property when you want to. The difference as to what fixtures may or may not be removed as the parties claiming them stand in one relation or another. These classes of persons will be separately considered, blah, 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 blah. Anyways, what's a fixture filing? It's personal chattel that's annexed to land. And a house is attached or set into the land, therefore it's actual annexation and so forth. It's personal chattel. Okay. Okay, so we're going to look at a particular set of facts having to do with Guadalupe Moya the fourth, and LaDonna Carol Moya, who, on their deed of trust and their warranty deed, are husband and wife. And so LaDonna, I've been talking to, she had gone down and done an assumed name filing on that name, right? Showing that her husband and herself are the owners. There's their signatures. done before a notary, as, him and her. The only thing I could see in here I would have done, I guess, is crossed out he and she, so it just said they, right? So there'd be no question there's two people involved, not a man or a woman or a legal fiction. But the great thing is they won't let you, right? You have to be a living person to do a notary, right? We're up here. Well, that isn't necessarily true. LaDonna Moya for and Guadalupe Moya for and LaDonna Carol Moya, husband and wife, isn't the same as Guadalupe Moya the fourth and LaDonna Carol Moya. So they have been separated. Okay, and so here, this is their warranty deed, general warranty deed. This is in Texas, and the grantee has got that name. That's why they went and did what they did, and they recorded it in the county. And then, well, Donna wanted to take this. But I told her, well, take it now and go put it into the property record where the grantee paperwork is, right? Because that's where the deed of trust is, or the warranty deed. Well, they wouldn't let her do it there. They said, no, you need to go to the land office. And so in her county, all these are in the same room, basically. You're not going to different windows or something. And so she went to the land window, and they said, well, she couldn't do it there either. But that ends up generating a letter that is sent explaining why she can't from what's supposed to be the district attorney's office, which the closer I look at it, well, this whole piece of paper is just one more simulated legal process. More evidence of a crime. And so at the end of the day, beyond doing the UCC filings, we're going to take it all. This is my idea. Let's see if they want to do it. And file a complaint with the elected prosecutor for the shit that's happening by his deputies behind his back. So either he's aware of it and he's a party, he's guilty of treason like they are, or he wasn't aware of it and he'll charge them with treason. That's your choices. You're either guilty of treason or you're going to charge them. Because these are offenses against the United States done by people who have taken an oath. And it doesn't matter what it is, brother. It's called treason, right? It may be, that's the nature. The cause is whatever the facts are, but the nature is treason. If you're somebody who has authority under the United States and you don't use that authority right, well, that is just plain out treason. You can call it many other things, but it's treason. And so, because people are committing treason, is the prosecutor going to do something about it? And that just fits into the other complaints I've been trying to put in here recently. I just want to get somebody arrested. Right? At the end of the day, I'm tired of fucking around with them in court. Just have them arrested and tell them to stop. Right? I don't care how long they go to jail for. You can let them out and say, well, that's your party foul, right? Don't get number two. And, 3 strikes, you're out like everybody else. But you can't go to court in a civil matter and be happy with getting a dismissal against you, or for any other matter as far as that goes. It's just, if somebody takes you to court and is dismissed, they ought to be arrested. But we should be able to do it long before we ever get into court, because what they're doing wrong starts long before you get into court. So it's an administrative thing, not really a judicial matter. Having an arrest warrant issued isn't judicial, that's administrative. That's somebody enforcing the law. Excuse me. That's what we need to have done. We need to have the law enforced. Okay, so this is her. That's the grantee. So that would be one of the people. And then in Texas, they have all this to have and to hold the property, blah, 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 blah. It talks about a vendor's lien and superior title. And somehow that the grantee has given that up, or the grantor has given it up without the grantee signing to it, because there's nowhere on this document that the grantee signs. So, they didn't agree to it. Somebody just did it. You can't do that in a contract. So that part of the contract would be void. If we were to read this thing where it talks about who's doing what, the grantor is going to certain real property together with all improvements located thereon, fixtures thereto, and any and all appurtenances belonging or appertaining located in Collin County, Texas, more particularly described as follows. Right? Unto the grantee. This is what the grantor has given to the grantee. But up here, it talks about the grantor for and in consideration the sum of $10 and other good and valuable consideration to the undersigned paid by grantee, the receipt and sufficiency of which are hereby acknowledged and confessed. Really, then he should stop right there because he's been paid. He's got nothing else to say. But he did, and for further consideration of the execution and delivery by grantee of one promissory note, that's the note we're talking about, payable to some legal fiction. Here and after, now he's the mortgagee. Before he was the lender, now he's the mortgagee. Changed his office. Now being secured by a vendor's lien and superior title. Herein retained, reserved in favor of the grantor. Well, how can the grantor keep the title to the property? He just said he had been paid for it. Right? So the whole thing is legally insufficient. It's just, nobody ever takes this stuff and complains about it, I don't believe. So that's what I'm going to complain about. The shit that's legally insufficient. There's no way the grantor can do this without the acknowledgement of the grantee, and the grantee didn't sign the warranty deed. Yada, yada, yada. To have and to hold, whereas, blah, blah, they signed it. Now, I'm used to seeing on people's paperwork, right, that, like a thing where the office has recorded it up here in this first page. But all that's up here is it says Chicago title, GF with some number. Okay, I believe that's a book in the recorder's office of the county for Chicago title and GF whatever number. If you went to that, it incorporates by reference where the rest of the records are that really tell us what's going on. Right? But we're never seeing those records. But otherwise, there's no indication on the front that this thing was ever recorded. Yeah, I know it's got a stamp, but where's the recording information, right, that it was done? Well, it's right here. This block you see here is actually on the back, right, where it says State of Texas, County of Collin, in uppercase over here, and then I, Stacy Kemp, County Clerk, I, Stacy Kemp, County Clerk, Court, Collin County, Texas. Well, where does that word court supposed to go with? I mean, this isn't a mistake. This is a stamp they put on that is written this way. So I believe it actually reads the state of Texas, I, Stacy Kemp, County Clerk, County of Collin, Court, Collin County, Texas. Right? She's the County Clerk, County of Collin, Court, Collin, Texas. I don't understand it, right? It doesn't make any sense. I don't understand why it's on the back. And you read on, do hereby certify that the foregoing instrument of writing is a full and true and correct copy of an instrument filed for record in my office. Day 9, September 2016, number 2016090900120530. Witness my hand and official seal at my office in McKinney, Texas, this 6th day of April, 2018. Stacy Kemp, Collin County Clerk. Right, so she just did this. But she's not doing the front, she's doing the back. There's nothing on the back. Right? So, LaDonna, I believe, she must have asked for a certified copy because it's got the court seal on it and all this other stuff, right? And so I guess what I need to do is go look online to see what it looks like online. But the reality is, this is the back side of the warranty deed for a piece of property in Texas. So if you're from Texas, listen up, right? This is you. This is how they're doing it where you are. They're probably doing it this way in a lot of places, but they're certainly doing it this way with you. And so Chicago Title, someplace there's a book in the recorder's office. And that number there is going to lead to something. But the question LaDonna is going to go back and ask is, well, why is this on the back? How come it's not on the front? There's nothing on the back. Certify that the foregoing instrument, there's nothing on the back. There's nothing written. So there is nothing officially recorded. I think it's something to take to the, to the prosecuting attorney. What the hell's going on in the freaking, this is a, oath-bound officer. What kind of shit's going on in their office? Now, the elected prosecutor will tell you, well, he doesn't represent the people, he represents the state. You say, correct. What I'm telling you is an offense against the state. It's an offense against the United States. Right? It's a violation of the Constitution. It's called treason. Because the first part of everybody's oath is to the Constitution of the United States. If you're in the United States, it is. Okay. So, beyond the fact that we're going to claim it on UCC-1, I'm just pointing out the shit that's wrong in these documents that I can see. Now here they had to make an addendum, correction to an instrument. And now it says the deed of trust that we're going to look at was executed by, Guadalupe and LaDonna in their full legal names, not as a legal fiction. There's no comma, husband and wife. Now it's just their full legal names. So they're trying to make this look like a legal document. Right, here's the legal description, which we're going to use on the UCC-1 filing. Okay, now here's the deed of trust. It's got a loan number. See, it's got the same filing. There's that Chicago title. Now look, here's what it says. Space above this line for recording data. Well, that would be the recorder's office, so they must have put it in there. Where is this at? How has this been incorporated by reference? Because that's what it is by being on here. It's incorporated by reference into whatever that number is, wherever it is. And there's the borrower, which is the same style that they used on the warranty deed. Again, a legal fiction. Right? There's the lender, which doesn't really exist in that name, but it has an address. So there's another one, and there's the third, the trustee. And if you look real hard, you'll find your owner's policy, Chicago Title Insurance Company, in which it says the name of the insured. So, now, does that common need to be there? I don't know how you do people with fours behind their names, right? It's like a little bit difficult for me to understand, but otherwise it looks like they're using full legal names. They have fee simple, but the title is insured as vested in, so these are the people insured, but the title is vested in these people as a legal fiction. Right? Because now they got husband and wife added on. So there it is again. And the reason I kind of show that is, where did I read that stuff at? Can I find that real quick? Yeah, this was something to do with Texas, purchase money loan transactions. That what it makes a defective deed. Where it talks about mistakes in the deed, such as faulty rendition of the grantee's name. or it is not uncommonly the case, by defective reservation and assignment of the vendor lien and superior title. I'd say they did both of those. So claims against title companies. Occasionally it is contended that there is only the title company's responsibility to review the deed for defects. The problem with that contention is that certain terms and provisions of every purchase money deed are vital to the interest of the lender, not vital to the interest of the title company, because their effectiveness is not ensured by the title policy. Of course, the settlement agent and insurer may be liable for closing a transaction with a deed that has an incorrect legal description or grantee name. And it did. It does. Because they created a legal fiction that hadn't been registered. Well, now it has been registered, right? That's the reason for doing the fictitious name, assumed name, whatever it is, right? And you're not putting your full legal name up here. You're putting the name of the grantee, the name of the borrower. That's going up there. If you're doing business in your name, your full legal name, you don't need to do this. It doesn't mean you couldn't claim to be the secured party. It's just you don't need to claim to have been doing business in an unassumed name. But somebody made that choice for you. And so now this has been done, right? And so what would you do? Well, if you fill this out, right? Robert Allen Rutluski with a phone number, your email address, send an acknowledgement to. Well, you could put Robert Allen Rutluski with your, if you've done a filing for sole proprietorship, and you're going to make the sole proprietorship the one that is the secured party, you could probably just put your full legal name and the address, like is on your SS4 form. That'd be the simplest way. You don't need to do it like I did. I just did it that way because I had done it that way before. So if I'm having it sent to me as a living man, but I'm having it sent to my business's address, then I'm having it sent care of my business's address to the owner. Right? What am I to my business? I'm its owner. But I'm not my business. I'm the owner of the business. Debtor's name. Right? So this is the name of the grantee, which is going to have the same address as you if you're living in the house, or it's going to have the address that is in the property address they use in the deed of trust. It's like section 4 where they talk about the transfer of property. But somewhere they give I don't know if she sent me enough pages to find it. Right, somewhere they give you a property address on the deed of trust. Right, because the warranty deed has been incorporated into the deed of trust. Everything has been incorporated in the deed of trust. There's the loan, it's incorporated in. This file's incorporated in. The freaking warranty deed's incorporated in because it's the property that we're talking about. It's all been incorporated in, so we're going to use the deed of trust as the instrument that's has the collateral that we want to have a security interest in. If you have the complete list of if you have the complete deed of trust, it's like section 15 that talks about notices. And if you read that, it'll take you back to another section. But eventually you're going to get to the section where they have the address of the property, right? And that's the address that goes with the borrower, because that's the address of the grantee, which I'm sure is your same address. If you're living in a house, it's the same address that you would be using, but I'm just saying this is where you would find it, and try to be consistent. Okay, so one debtor is the grantee, one debtor is the lender. The third debtor, because this is a deed of trust instead of a mortgage, is the trustee. All of them as organizations, none of them as individuals, using the addresses that you find on the deed of trust for each one of the entities. The secured party, though, well, that's you and your full legal name. Now, you can do it as an organization, but technically, there is no difference between the business. The IRS sees no difference between the business and its owner, right? To them, it's one entity. So you could do it as if you haven't done a sole proprietorship, you could do it Britluski, Robert Allen, mailing address, right? If you're married, your wife could do the same thing. I would use my full legal name because you haven't changed them. But, she'd put her maiden name here and her first and middle name here. You'd be done with it. Right? If you have gotten a sole proprietorship and an EIN number and say, well, I have a business, I'm going to do business as a business, well, then put your business name there. Robert Allen Retluski. See how that works? Then what's the collateral? Right? Well, I would say the collateral is all the real and personal property incorporated by reference in a deed of trust recorded in the office of, now you got to find something here. What do they got? Or filed and recorded. So a deed of trust filed and recorded in the official public records, Stacy Kemp, County Clerk, Collin County, Texas, 9/2016. Basically, whatever you find for the recording thing, put that down as the collateral. That record is the collateral, right? And all the personal and real property incorporated within. So I have to think exactly how to say that sentence, but let's think about this just for a second, because it don't need to be that hard. Collateral, all real and personal property incorporated by reference in a deed of trust, filed and recorded in the official public records, Stacy Kemp, County Clerk, Collin County, Texas, on 9/9/2016 at 02/11/28 p.m. as instrument number, and whatever the instrument number is. Okay, and so that's the collateral, the property that's in there. And if you're doing it as real estate filing, then really that's all you do on the first page. You do the first four, and you don't do any more, according to the way I read the instructions. And then you go to the back. Name of first debtor, same as 1 or B. Yeah, whatever. Debtor name, right? Provide 10A or 10B for one additional debtor, because you couldn't get them all on the front page. So here's your third one, right? Additional secured party, the husband or wife, right? Or a signer, secured party's name. You guys have to work that out. I'm not getting into that deep. Additional space for collateral, well, you don't really need it, but you need to check box 13 because you want it to be filed in the real estate records, and that takes care of one of those caveats that you need to take care of, and filed as a fixture filing. And then name of address of record owner, well, that's you and your full legal name at your address. And description of the real estate, well, that's the legal description that they show all over in the deed of trust. Right? Where's your legal description? What we got for that? Let's find a legal description. Hey, there's one. Right? Make sure it's the proper one, but that looks like a legal description to me. And that would take care of, well, what box was that? 16. And you're done. And then go record it in the office, in the county, where you record UCC-1s. Because it's real property. But by, checking this box and checking that box there and putting the information here, you fulfilled the things that were on the other page, or in the thing I was reading earlier, that it takes to be able to do it. And it's just, you're the record owner, right? So this is you and your full legal name as the owner. And when you file this in, the state will agree with you, and the county will agree with you that you're the owner. Amen. Let's see if you get some mail. Right? That's what I'm waiting to see next. Well, what happens? Are we going to get any kind of mail? Well, very cool. That's really all I wanted to get into. It's more a matter of doing and seeing what happens, right? I did want to show one thing of interest, though, and let's just show that real quick, because I don't know how well I talked about this. This is about the 4th time I started this video, so I've talked about a number of things a number of times, but maybe some in one video and not in another, and so I don't really know if in this video I've talked about everything I've been talking about. You understand that? That's how crazy this stuff gets. It gets overwhelming some days. But because LaDonna had done the assumed name certificate, and then went back to say, okay, well, it's recorded in vital records, or maybe it needs to be recorded in vital records. This is based on the wording that she had said. I got to pull this guy's website up. Hang on a second. Shoot. Okay, so because LaDonna had done this fictional assumed name certificate, and then went back and said, well, okay, I want to put this into the property file where, Guadalupe Moya IV and LaDonna Carol Moya, husband and wife is being used. And so she went to the property office, the property window, where you would get your warranty deed. They said, no, that's the wrong window. You got to go to the land window. She goes to the land window, and they say, well, no, you can't do that here. Now, I don't know if she pressured them into this, or if this was on their own accord, to cover their own ass. But they sent her a copy of a letter that was sent to Stacy Kemp, county clerk. Now, this is Stacy Kemp, county clerk's office, right? Which isn't quite the same as the one we've been seeing. No, not that one. Where's the one that, where is the one? That's the other one. All right, this one. So if we were to compare these, I, Stacy Kemp, county clerk. Well, let's go down to here. Stacy Kemp, Collin County Clerk. Stacy Kemp, County Clerk, County Clerk's office. Right? With a comma. Well, that's like, it's like a legal fiction. It isn't her office. I mean, it isn't the office that she was elected to. But nevertheless, it said request to render opinions as to whether to file documents regarding somebody. So I guess they decided to go ask some questions. Dear Ms. Kemp, you sent the Collin County District Attorney's Office, keep that in mind, a request to review the attached documents to determine if they should be filed by the county clerk's office. I received this request on the 18th, 2018, April 18, 2018, and have reviewed the documents and recommend that they not be filed. The clerk of the court, I thought we were talking about the county clerk, but the clerk of the court now has a ministerial duty to accept a document for filing and recording only if it is required or permitted by law to be recorded. The VTCA, Local Government Code, Section 192.001, if no statute authorizes, requires, or permits a document be filed in the clerk's office, she may not accept it for filing. Numerous Texas Attorney General opinions interpret the above statute to require the document to be regular on its face and to state the clerk must be able to determine from the face the document that complies with the applicable statute. See some Attorney General letters. These documents do not reference a statute that authorizes them to be filed and do not appear to belong to any pending case in Collin County. Collin County does not have an administrative or maritime courts. If you have any questions, do not hesitate to contact me. Sincerely, some scribbling, Debbie F. Harrison, that would be F as in the middle initial, alleged Assistant District Attorney, Chief Civil Division, Collin County, District Attorney's Office, yada, yada, yada. That really looks official. There's only one problem with it. There is no such thing as the Collin County District Attorney's Office. Because Collin County doesn't have, by that name, they have a criminal district attorney who has an office. And he says the office is, I guess this one's better, the Misdemeanor Trial Division of the, what is it now? Collin County Criminal District Attorney's Office. That's the name of the office. Not Greg Willis, Criminal District Attorney, Collin County Courthouse. That isn't the office. It's not Collin County District Attorney's Office. No, it's Collin County Criminal District Attorney's Office. And look at his seal. It says District Attorney, Collin County, Texas. Well, is that what we saw on the seal that they used here? Well, no, this says the state of Texas. Wow, that's a false seal. Counterfeit seal. Some kind of seal. It ain't the seal of the criminal district attorney, according to him. He's got his own. It says District Attorney, Collin County, Texas. So the important thing to understand is that's the office that you want to go to them in. District Attorney, Collin County, Texas. And this is why this is stuff is so crazy. The level that they do when they start playing with the words. Here's another one. Let's look at this Kane County. This is in Illinois. State's Attorney's Office, Kane County, Ill, with ILL. He has the only office in Kane County that has ILL behind his name. Most other ones say Kane County IL. But ILL is the proper contraction to use, abbreviation, contraction, whatever the proper thing for it is. It's what they use in all the state laws and Supreme Court stuff, right? That to do with the Constitution. Anything to do with what you would think is the government on paper is ILL. And yet, all the things that they go to like St. Charles, right, is in IL. It's not in ILL. So you need to go to them in this office. This is the office where they're representing the Republic state. This over here is where they're representing the legal fiction. Kane County State's Attorney's Office. Right? That isn't what the official name is. The official name is State's Attorney's Office, Kane County, Illinois. Right? This is Republic and this is democracy. This is where Talmudic law is in effect. This is where one nation under God is. We need to go to this man, whatever the county prosecutor is, wherever it is, whatever they call him, in his state hat, and make it an administrative matter and say he has to, you want him to take your sworn statement and issue an arrest warrant in accordance with 18 USC 3041. Give him a copy of it for offenses against the United States because people are violating the Constitution. They've taken an oath to the Constitution and they're not supporting it. They're not defending it. They're warring with it. Because most of these people, when they take an oath, they didn't even take it in their full legal name, but they didn't take the proper oath to start with. It's in the Constitution. And they said, so help me God. So God doesn't care. You just invoked him into your oath. He knows who you are. So all those are, sworn before God. That's what I'm thinking. And so we're going to write this gentleman about this letter. Because I remember where I put it. Saying that, what the hell's going on? Who the hell is Debbie F. Harrison? Assistant District Attorney, Chief Civil Division, who's using your name on a letterhead saying this came from your office. Having to do with an issue that didn't have to do with, and start pointing out the things that are wrong. Like, it wasn't for Guadalupe Moya and LaDonna Moya. That wasn't the names that were used. It wasn't to do with the clerk of court. It was to do with the clerk of the county clerk. Right? But not this county clerk. This county clerk. Right? So this whole piece of paper that this attorney wrote is nothing more than a simulated legal process. Done under color of law. That's depriving people of their civil liberties. So because of what they're doing, just because of this one piece of paper is a violation of the Second Amendment, having to do with being secure in your persons, papers, houses, and effects. That is Second Amendment, isn't it? I should make sure. I'd like to be right about such things. Now it's a Fourth Amendment. Shoot, that's what it is. Although they're probably violating the Second Amendment too. It'd be the Fourth Amendment. Or it's the Sixth Amendment. It's one of those amendments. Come on, computer. Oh, please forgive me. Fourth. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. They're violating that. They're taking people's property when they're not using their person is their name. That is, if you're not using the name of the person, you just created a thing. So they're making all persons things in rem jurisdiction instead of in persona. And so they're not secure in their person. They're not going to be secure in their house or their papers or their effects. Because somebody who who also isn't using their full legal name, is going to take all their property under that particular deed of trust in a foreclosure. Screwed up that that's what they're doing, but is what it is. Okay, one more thing to show, then we're done. Okay, last but not least, this is out of Arizona, where if you were to look, there's not a lot about registering your fictitious name in the county in Arizona. But there is in the Arizona Revised Statutes in 44.1236, certificate of name required. Any person other than a partnership transacting business in this state under a fictitious name or a designation not showing the name of the owner of the business or the name of the corporation doing such business shall record with the county recorder of the county in which the place of business is located a certificate stating in full either the name of the owner of the business and his or her place of residence, signed by the owner and acknowledged. In that acknowledged part, you need to, that would be like a special certificate by the notary, a special notary act, right, for an acknowledged certificate. I'm believing it. But maybe it needs to be acknowledged by the county. Point is, it needs to be acknowledged. If a corporation, the name, business, name, and address of the corporation signed by a statutory agent and acknowledged. Well, what if you don't do it? A person or corporation doing business contrary to this section, which would be you buying a piece of property, and being on a warranty deed in any name other than your full legal name, you would be contrary to this section, if you were in Arizona, shall not maintain an action upon an account of a contract or transaction made in the fictitious name in any court of this state until such person has first recorded the certificate required by this section. Which to me is what we did by doing the assumed name thing. And so if you're in a court case and you did it, if nothing else, put it into your court case. I still believe it needs to get in the property file, but go file it in your court case if you're in a foreclosure. Claim the name of the borrower. Claim the name of the grantee. On a form like this, whatever it is, put it there with the address, which is going to probably, we're talking foreclosures, be your address. And then the owners and their full legal name. Not backwards, not surname, comma, no. Full legal name. Before a notary. So, like this must be an acknowledgement, right? That's what I would say. They're acknowledging it. The grantee. And go file it into your court case. And say you're there representing the grantee. Because it isn't you, it's just a legal fiction. So now you're the attorney for the grantee. But, we really don't want to be in court. But if you needed to do it today to get it to stop, that's what you should do. I'm thinking. We'll see how it goes. We'll see if any of this pans out to anything. But I'll let you know what we find out. We'll see you all soon. Take care.